Okay, let's now bring this into committee. Councillor Vaughan, questions of staff.
Just a couple of questions, and the housing, affordable housing component on page 20. Sorry, I lost the page number, but this site qualifies as a to have a mandatory, it has a mandatory requirement for affordable housing on site. Is that right? It's over 5 hectares.
It requires it as part of the. It requires it as part of the housing first policy in terms of disposal of city lands.
Louder, please.
It requires it as part of the housing first policy in terms of the disposal of any city land.
Okay, so there are two policies governing this. One is city lands must be offered up for affordable housing, and the second one is that any development site over 5 hectares must include 20% affordable housing component. Is that right?
The first part is correct. The second part, it's up to interpretation because the quadrant is 4.2 hectares, but there's a multiple ownership. So I would say the first category would apply clearly, which is the housing first policy.
Okay. The second one is, I was wondering if legal could comment on the motions that aren't quite drafted. I haven't seen them in front of us, but the motions, as I understand them from Councillor Walker, are around the strata sale and inserting conditions of the land transaction into a planning document.
We'll put the motions up on the screen, so everyone will have the benefit of legal's advice.
No, what was the question?
It's going to be at the strata.
Can you scroll that? Good, thank you.
Sorry, your question was?
Well, this seems to, I understand strata sales and understand how they afford a degree of certainty to the community, but I guess my question is, can you insert them into a planning document? Aren't they in fact part of a different? You don't.
Planning staff feel that it is appropriate.
It's actually a question more to legal.
Oh, sorry.
Yeah.
Yes, thank you, Mr. Chairman. Our advice has been in the past on these matters that you can use strata plans on the sale of city-owned land. Our view is that it is a separate process. It's something that is dealt with through the sale of land process that would be done through the Government Management Committee, whether it's by request for proposals or however. However, I can't say that including it here would be illegal, but it does raise a question as to whether this is the appropriate place to put it. I note as well that what starts out as a recommendation from planning staff that strata plans to limit height may be utilized through the motion becomes stricter and ups the commitment on that somewhat by saying that it shall be utilized rather than may. So the recommendation from legal services would not be in favor of policy 6B or as amended.
And that's because?
That's because there is a separate process by which land is sold, and it shouldn't, in our view, be mixed in with the land use planning process. In this case, there is an accompanying zoning bylaw which would set the heights, and that's the way to implement a policy in an official plan rather than through this method. But I understand that it's been to the TTC and that they're aware of it. So we're not saying you can't do it, we're just saying it is a separate process, it's not our recommendation.
And what impact would that have on a land transaction?
Speak into the microphone, please.
What impact would that have on a land transaction negotiation down the road if it was written into the planning policy?
The city is not supposed to pass bylaws or carry out any public works or conduct itself in a way that's inconsistent with the official plan. So it would be a matter that if this is adopted, City Council would be adopting a policy directing itself to take that constraint into account when doing the sale of the land later.
And if privately owned property in the area, if it was transacted, because it's not registered on title, would the courts read that as preempting the planning process? In other words, sort of a backdoor method to achieve a front door objective?
This only operates with respect to city-owned land. This is the city imposing a limit on its own land. It doesn't really have any effect on privately owned land.
Right. But what would stop a future purchaser from the city of appealing this provision and asking for relief from a planning document that prejudged the planning process and effectively trumped their ability to go to the OMB.
An owner of land who is affected by policies in the official plan or is affected by a zoning bylaw always has the right to apply for an amendment to an official plan or an amendment to the zoning bylaw. What is being suggested here is a constraint on the sale of land where you would only sell essentially a box of air, which would have a top layer on it. So in that case, it's not really a matter of anything being appealed, it's a matter that that's all you would sell.
Right.
And the idea, I believe, is, although no figure is mentioned in Policy 6B, is that the upper limit on a sale would reflect the upper limit. That's the 120 meters or 85 meters for that particular block.
And so the city would own above 120 meters going forward.
Yes, retain ownership of.
Okay. All right.
Okay, Councillor Milchin.
Thank you, Mr. Chair. It's
My colleague, my colleague, Ms. Fisher, would like to add.
Thank you. Just from a real estate law perspective, I just wanted to address Councillor Vaughan's questions, is that from a real estate law perspective and from real estate services perspective, who I understand has waded in on this as well, the concern is that there is no potential transaction in front of committee, and that in our view, it's inappropriate to be prejudging what will happen on the sale until that sale process has been engaged. The zoning bylaw in front of you deals with height, and that in itself precludes certain things from happening. But to also add another layer precluding what should happen or dictating what should happen in a sale, particularly when these lands are, for instance, on the list of Build Toronto potentially to be looked at, and there are policies and reports that City Council has adopted as to what BT should be doing with land in terms of unlocking value, that it's premature to be looking at dictating what happens on the sale until the site is looked at from a city's perspective, and in fact, a TTC perspective, which actually owns it, as to its future development.
So on balance, are you recommending deletion of 6B? That's before us on the screen.
Yes, I would recommend deleting 6B, but also the other motion that Councillor Walker have moved also relate to the very issue of dictating what would happen on a future sale of the property, which is not yet in front of you. And I understand exactly what Councillor Walker is attempting to achieve, but at this point in time, the zoning in and of itself would dictate what can be built on the site if you adopt that.
And that's 10 and 11? Do you want to put 10 and 11 on the screen, please?
Yeah.
Councillor Walker, please.
Yeah. Yeah, recommendation 10. I mean, recommendation 11, I think, was intended to follow 10, but
So you're okay with 11?
I think at this point in time, I would indicate that until you're looking at a sale process, that 11 is premature as well.
Okay. Councillor Milchin.